Welcome to Out of Court and Out of Conflict, presented by Wasinger Law Office.
Welcome to Out of Court and Out of Conflict, your guide to estate law and probate solutions by Wasinger Law Office. Join us today as we unravel legal complexities and secure your family's legacy with experienced attorney Matt Wasinger. I am your host, Kevin Rosenquist, and today's episode is Safeguarding Your Legacy, Wealth Preservation Strategies for Florida Families. Matt, welcome back.
Excited to be here.
All right, well, let's get into it. What role do trusts play in wealth preservation?
With the revocable living trust, which is the foundational planning, revocable meaning it's changeable as long as you're alive and the decisions you've made, it acts as a funnel for your assets and your money to be passed down in a way that you specifically designate, as opposed to a will or with no estate planning in place, let's say at all. Then it's going to court, and the judge is going to most likely, if you have minor children, have that money go directly to the guardians for the benefit of those children, whoever ends up being nominated as guardians. The other thing is, if your kids are 18 and you don't have a trust set up to determine when that money should be doled out, that money is going to go outright to them and in their bank account when they turn 18. Sometimes that's okay. If you have no qualms about giving your children however much money is in your account to your assets total after they've all been liquidated, that's great. But most people realize that having an 18-year-old with $100,000 in the bank, or sometimes significantly more if you have a house and you have a couple insurance policies, that can be a lot. It's probably not the best idea. So the biggest way that trust can help with wealth preservation is ensuring that the money is spent properly and or grown properly for the benefit of your beneficiaries after you're gone, whereas you just can't do that very well or at all in some cases with a will.
Yeah, if anyone needs any proof of that, just see what some of the young athletes do when they get into the pros and just blow all their money in like the first year.
Yeah. Well, I'd like to tell clients, I would like to believe I was pretty smart with my money even when I was younger, but I still would have bought a lot of stupid stuff.
Oh my gosh. I did buy stupid stuff and I didn't even have that money.
Yeah, exactly.
So what other types of trusts are there available in Florida, and how are they used?
Well, there's a million different variables of trusts, and they're all acronyms. So there's SLATs and GRATs and IDGT trust, things like that you can put in place, but it's very specific to the individual and their family situation, their financial situation. In most cases, for most people, just the foundational trust with some options to go down into an irrevocable trust after one of the spouses or significant others pass, and then after they both do down to their children or their beneficiaries is enough. The revocable living trust with options built into it to pass down the money that they need to is typically enough for, I would say, 90% of people. But when you start worrying about the estate tax exemption, or you have family dynamics that you feel or require doing all these specific trusts, there's a million different options out there, but they end up being a little overkill for most people in most situations.
So for us lay people, we hear will, we hear trust. What are the benefits of a trust over a will, and who should consider the trust most?
Well, I tell people, if you have minor children or you have any assets that you don't want to go through probate and you want to ensure that they don't go through probate, then setting up a trust is the only way to guarantee that. There's ways to title your assets with just a will so they skip the probate process, but those aren't foolproof because they require people to constantly be updating those beneficiaries in those documents. Whereas if everything's in a trust, it's just going to pass down through the trust how you've previously set it up without having to go through probate, and it's predetermined. So you don't have to worry about changing your beneficiary designations because it's going through the trust. It'll get down to the people that you need it to that way. The other thing is a trust kicks in even if you're incapacitated. It's functional in that situation. A will only kicks in once you die. So a trust allows your successor trustee to handle your affairs and your assets without, even when you're incapacitated, Whereas with just a will, if you're incapacitated, as long as the power of attorney gives you that authority, then you can do that. But if not, you're going to have to go to court to get authority to be able to handle all of those things. So it's a much smoother transition if for any reason you're incapacitated with a trust than it is with a will in most cases.
Okay, that makes sense. And you mentioned the estate tax. Like, how can Florida's unique estate tax laws impact trusts and wealth preservation strategies?
Well, the great news is Florida doesn't have an estate tax. It's only the federal tax. And right now, the federal estate tax exemption. So the estate tax is the federal death tax. It's taking 40% off the top of all the assets you're based on your net worth, all of the assets you've already paid taxes on. But they give you an exemption amount that's like a coupon you hand in. If your net worth is underneath that number, you don't owe anything. But that number changes all the time. So right now it's $13.61 million a person.
Oh.
So if you're married, you're $27 million. So for 99% of people, that estate tax exemption is not going to be something that you have to be concerned with.
Right.
But as I tell my clients,
be concerned with it. That's for sure.
Yeah. But I tell my clients all the time, we keep track of that. That's why we always bring our clients back every 3 years to see what's going on, because it changes all the time. In 2026, it's supposed to sunset down to $6 million a person.
Oh, wow.
Which is still, it's still pretty high. But in 2008, it was only $1 million a person. So in today's real estate market specifically, if you have a house, you've got a couple retirement accounts, and you have any insurance, you're going to hit that $1 million threshold pretty quickly. So the way you build your estate plan to avoid that estate tax is very important, because you're going to change the way that you build your estate plan altogether. You're going to take advantage of some of those other types of trusts out there to avoid paying that 40% off the top. Because unless you are just extremely wealthy, taking 40 and don't care, 40% off the top of anything, is a lot, and not something that you typically want to take away from the people that you're leaving it to. It could continue to go up. They can change, make sure that it doesn't sunset in 2026 and keeps going up with inflation, or they can just get together and decide, hey, we're gonna move it back down to $1 million. I mean, it changes all the time, so we want to continue to monitor those things.
Definitely, yeah, for sure. And can you talk about the role of the trustee and maybe some of the factors that you generally recommend people think about when choosing a trustee?
Well, the trustee is going to be someone, in a certain respect, it's similar to how you're choosing guardians. You want to choose someone that is going to follow the terms of your trust and do their best to follow the terms of your trust to exactly the way you want to. Because a trustee has a fiduciary responsibility to act in the best interest of the beneficiaries. But that doesn't mean that they have to be a financial wizard to be your trustee.
Good point.
They have the ability in these documents, if they need to go hire an attorney, they have got the authority to go do that. If they need to go hire a financial advisor or a CPA or things like that, they have the ability and should be doing that. So as long as you're choosing someone that is going to actually follow the terms of your trust and not be a trustee that down the road your kids or your family members and beneficiaries are trying to remove because they're not doing that, that's our number one goal. Kind of like with the guardians, we want the number one goal to be the people that would raise your kid the way you want it to. We want someone that you trust to run the trust exactly how you set it up and not create problems down the road for any beneficiaries.
Makes sense. For individuals with significant wealth, what are some advanced trust strategies that you recommend for protecting assets while ensuring family control?
Well, so that's where the rub is. It really is extremely dependent on a family's financial situation, obviously, but their business assets, right? Mm-hmm. There are some people that have a high net worth that need to worry about the estate tax exemption, but because of their business, they need access to their assets. They can't put them into one of those more complicated irrevocable trusts, because then it takes away their ability to access those funds, because they can't. If you're trying to take money and put it somewhere where the government and creditors can't touch it, that means your access is going to be limited and or cut off in some instances, and you've got somebody else handling that, right? So when you're doing that, it's really dependent on what the person's financial and business and family situation is. But, one that's, the hybrid asset protection trust is one that is a great one, where you can designate your spouse or significant other to be the trustee of your assets, but you could, in limited cases, put yourself back in as trustee and things like that. But it really we start getting into the legal weeds here and technical terms when we start talking about that stuff. So like I said, most of the time we're not, unless we've got a client that needs it or is worried about it. Those are things most people don't need to worry too much about.
What are some of the common mistakes you see people make when they're setting up a trust?
Well, the biggest one is people don't put their assets into the trust, what we call funding the trust. They don't title them to go in there. So when they come in, like 9 times out of 10, when someone comes into our firm and they've got a trust set up, almost nothing is in it. Or because the traditional way of estate planning is you go get your trust set up, they give you some instructions on how to fund that trust, and they send you on your way, and people just get busy and don't worry about it. They don't think they need to. But what they've come in with then is an expensive paperweight, right? Because the trust isn't doing all the things you need it to. So we only give people, once they sign, we give them instructions, we give them guidance on how to do that, but we won't hold their final meeting until they put everything in that trust. And the whole point is we want that trust to work for you. So that's the biggest thing, is people get busy, they forget, or they don't title assets properly when they've set up a trust. The other thing is, if you're DIYing a trust, you have no idea what you may or may not be in there. For instance, we include a supplemental needs, special needs trust option in all of our trusts. So in that instance, there's an ability to create a special needs trust that's an irrevocable trust for the purposes of someone that needs it, because then they can still get government assistance, qualify for it, while having additional monies there for, to help with their situation or, their lifestyle to be raised, whatever the situation is. And that's not always going to be just thrown into a DIY trust. Or if some of these trusts I've seen attorneys they're 10 pages long. That's not going to cover most of the things that you need to cover, because there's a whole bunch of, while it mainly seems like legalese to most people, there's a whole bunch of language you need in there to make sure that taxes are handled a specific way, now that your businesses are handled a specific way, that if there's a special needs trust for any reason, that ability is in there. And so having someone that's experienced and knows what they're looking for and be able to talk through those things with you once they get a sense of your family dynamic and your financial situation is key to setting up a trust that actually works when you need it.
How often do you recommend people revisit their trust and kind of meet with you and see how things have changed and whether their goals have changed and whatnot?
We do that every 3 years. We recommend every 3 years. We always tell our clients, if something happens or you've got questions, don't wait for the 3 years to come fix it. But we do that because, every year is a lot if you're setting up a trust in most cases.
Sure.
But every 3 years gives enough time that, in a lot of situations, maybe some people's health has changed. Maybe their goals have changed completely. And the other part of the equation is maybe the law has changed and we need to address some things that maybe we didn't contemplate or were handled differently previously, that we want to make sure doesn't become a problem for your specific estate plan down the road. And so then we'll have those meetings, and most of the time we'll just do it via Zoom. And if everyone's on the same page and they've got all of everything where they need it to be and all the same people in the same places, then it's a 15-minute meeting and we're just checking in and going from there.
And should people make changes if they have significant changes in wealth or if they acquire assets, if they buy a vacation home, if they do anything that's more of a major purchase or anything, is that something that they should revisit immediately?
Yeah, I mean, it really depends, on how you set up your estate plan and the options that you have. You want to make sure that, at the very least, reaching out to make sure that you're titling those new assets in a way that still funnels and works with your trust. And if anyone's doing that, we typically reach out, you've got some major financial change, don't hesitate to reach out. Let's talk about it and see if there's anything that we need to do differently. Because maybe it's nothing. Maybe it's, hey, just make sure you title your LLC that you bought that rental property with to be owned and or funneled to the trust, right? So that way it's not left out. This new asset is that could be a very valuable asset is left out and has to go through the probate process.
Okay. And if anyone's listening right now and is like, I really need to look into this, I need to start thinking about my wealth preservation. They want to come talk to you. What should they do to prepare for an initial conversation with you?
Well, so what we do when we're doing what we call our family planning sessions is we have them complete some homework that outlines not only their family information, but their financial information situation. And we have specific questions in there about their goals, what they're trying to accomplish, what they're trying to avoid. And that we make them complete that before they come in for that session. So we can give them a real answers about what they're trying to accomplish as opposed to just giving them a bunch of hypotheticals. But we also offer a free 15-minute consultation if they want to just ask some general questions, maybe even just about the process or what they should do. We have that ability as well to kind of just get them set up. So the number one thing I tell everyone is, sit down if you're married or you've got a significant other that or partner of any kind, sit down and discuss what your goals are for if something happens to one of you to make sure that it's covered, and then come talk with us about any, and start drawing up questions from there. Because normally just having that conversation, what happens to our house if we pass and we have our kids? Do we want our kids to try to stay in it? Do we want to sell it and keep the put the money somewhere else for the benefit of our kids or whomever? Just starting to discuss what happens, what do you want to happen after one of us passes? We'll start bringing up questions for you that will be pertinent to us and for your estate planning.
Great. Well, thank you for tuning in to Out of Court and Out of Conflict with experienced attorney Matt Wasinger. For more information or to connect with Matt, visit wasingerlawoffice.com. And of course, please like, subscribe, and review our channel. Matt, it's always great to connect with you. Thanks so much for being here.
Thanks for having me, Kevin.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.